Counsel at the Constitutional Accountability Center in Washington, D.C. I just finished listening to telephonic oral arguments in two major cases at the Supreme Court today concerning President Trump's financial records. The first case was Trump v. Mazars and Trump v. Deutsche Bank. That case dealt with a set of 3 congressional subpoenas for various financial records from Mazars, Deutsche Bank, and Capital One. The second case that the Supreme Court heard was Trump v. Vance, which concerned a subpoena from the New York District Attorney's Office and a New York grand jury for Trump's tax returns from Mazars. The arguments were really fascinating to watch, and I'd love to go through some of my observations about what happened today. But the bottom line is that both of these cases concern whether or not the court is going to make sure that the president is accountable to the rule of law, or whether the court will hold that the president is effectively a king and doesn't need to follow the ordinary rules of process and of complying with subpoenas. And while I think it's hard to know exactly how these cases will turn out, I think there were a lot of notable moments during the argument of the justices grappling with these cases and understanding the implications of them. So starting with the Mazars and Deutsche Bank cases, as I said, those cases deal with congressional subpoenas. Congress has long been held by the Supreme Court for many, many decades now to have very broad authority to investigate any matter on which legislation could be had. Basically, any area where Congress can legislate, Congress should also be able to investigate to the fullest extent so that they have the information that they need to decide whether or not to legislate and how to legislate. And so these cases deal with that power, and President Trump has basically suggested that Congress doesn't have the power to request his financial records for legislative purposes. One of the really important things that came up in the Supreme Court's argument today is the really long history of congressional requests for information, dating all the way back to the very beginning of the Republic. The House Counsel argued, in his argument, he noted that even during the Washington administration, Congress requested documents and other materials from President Washington and his administration with regard to the St. Clair military expedition. And President Washington complied with that. And so, that long history is something that CAC brought up in its amicus brief that we filed in the Mazars and Deutsche Bank cases, and it featured prominently in the argument as well. Another aspect of the history that came up is the fact that more recently, during the Watergate affair during the Nixon administration and the Whitewater affair during the Clinton administration, Congress, got a whole variety of information, of documents, and et cetera, from those two administrations. And it was interesting because one part of the argument that was really notable was Justice Kavanaugh asking about and a couple other justices as well, asking about the Whitewater inquiry during the Clinton administration, and basically asking, well, in that case, Congress received a variety of information from the president, as did the Department of Justice in that case, and basically asking, well, if that was okay, why is this not okay? And the Trump attorney didn't have a great response to that. And those cases are the current case and that case. They're a bit difficult to distinguish. Another important part of the argument was Justice Ginsburg's question about, in particular, the Oversight Committee's subpoena for Trump's financial records from Mazars. The Oversight Committee is requesting those documents because it's considering potential legislation in the area of presidential conflicts of interest and financial disclosures. And this is something that clearly is an issue with this president. A lot of news reports and reporting has suggested that this president may well have conflicts of interest that affect his ability to impartially do his job. And this president has been unique in that he has not released many of the same financial documents, including specifically tax returns, that previous presidents have released. So this is an area that the Oversight Committee has been investigating about new potential legislation. And Justice Ginsburg, asked the very good question about why is it that Congress can't request these documents to decide, in particular, whether or not to improve or expand the protections, the requirements that already apply under the Ethics in Government Act. And that's an important question because the Supreme Court has said repeatedly that Congress has the power to request documents that are, at all relevant to possible future legislation. And in this situation, the House has pointed specifically to the Ethics in Government Act and possible strengthening of that act as its legislative goal. And there's been no suggestion that it's acting in bad faith or otherwise, that's not really its goal. I mean, it really is considering that. And so one would think that understanding the president's potential conflicts of interest and other financial entanglements would be really important to knowing whether or not to legislate in that area. And the Trump Counsel really didn't have a great response to that. Finally, I think a really important aspect of this case is that there is an Intelligence Committee subpoena at issue here too. The Intelligence Committee is considering what legislation it might need to pass in order to prevent foreign interference in our elections. And to that end, it is seeking financial records related to President Trump and his businesses to understand if the president's entanglements in some way allow a foreign country or a foreign government to be able to influence him or be able to influence our elections in other ways. And one issue that came up during the argument was the question of whether the House really needed financial records from President Trump going back to 2010. And, the answer that the House counsel had was basically, yes, they do, because President Trump has been, thinking about running for president for quite some time. And it's important to understand what his conflicts might be and whether any legislation might be proper to deal with any of his foreign connections or entanglements and any interference that foreign countries might be having in our election. And that issue really continues to be so important given that we're very close to an election this fall. And so the issues that the House is considering in that area are especially important to this day. And really, the importance has only increased as we move closer and closer to an election. So, all told, I think it's hard to predict exactly how this case might turn out. There were sort of questions for both sides and a lot of issues that the court dealt with. But I think the House counsel and many of the justices made clear that there really are a whole variety of legitimate purposes to the subpoenas that Congress has issued from all three committees, the Oversight, Finance, and Intelligence committees. And, the Supreme Court has for a very long time held that these types of subpoenas are proper, so long as they are in furtherance of this type of legitimate legislative investigation. And so it remains to be seen whether the Supreme Court is going to hold this president accountable and apply its own long-standing rules about congressional subpoenas to these cases. Second, the Supreme Court then turned to the next case, Trump v. Vance. This case is quite different. It deals with a subpoena from the New York district attorney that's part of a grand jury investigation of possible campaign finance violations. And the president has challenged this subpoena on a very different theory than in the congressional subpoena cases. He said that basically he is absolutely immune from any criminal process of any kind because he is the president, and this grand jury investigation pertains to him and is a subpoena for his financial records from a third-party accounting company, and that this immunity basically covers that type of subpoena and precludes any enforcement of it. I think the key issue that came up during the argument really was a comparison of this case to a prior case called Clinton v. Jones, Paula Jones. This case arose during the Clinton administration, of course, and it was a civil suit against President Clinton for alleged sexual misconduct. And the court had to consider whether a subpoena for the president's testimony while he's in office and the possibility of a civil trial while he's in office were permissible, given the immunities that that presidents get while they're in office. And the court said that those things could go forward, that subpoena could go forward, and that a civil trial could go forward. And given that decision, it's really difficult to distinguish this case. And a lot of justices asked many questions of President Trump's lawyer, trying to figure out why, if that case came out the way that it did, this case should come out any differently. One key point was the fact that in Clinton v. Jones, that case dealt with a deposition of the president while he was in office. It literally took his time. He had to devote time to complete a deposition. That's quite different from this case, which is simply asking for financial records from the president's third-party accounting firm. The president himself doesn't need to do anything at all. Another issue that came up was this question of stigma. One of the things that the court has thought about when it comes to how far the president's immunity extends is whether any particular judicial process would result in a certain kind of stigma to the president and the president's office that would make it impossible for him to do his job. And a couple of justices brought up the important point that, despite the fact that this is obviously a criminal grand jury investigation, the documents that the grand jury would get if the court sides with the New York District Attorney's Office would remain secret because they're grand jury records. On the other hand, in Clinton v. Jones, although it was a civil matter, we were talking about a civil suit regarding sexual misconduct. So that really, there was a stigma there that the court said was not enough to preclude that type of subpoena. And so it would be strange for them to say that the stigma here of a secret grand jury subpoena would be enough of a stigma to preclude it. The third interesting point with Clinton v. Jones is that, one issue that the Trump lawyer brought up multiple times is this notion that, if this court allows this subpoena to go forward, 2,300 district attorneys, across the country might be incentivized to file subpoenas against the president and in some way, harass him. But the important point with Clinton v. Jones is that the court actually considered that same issue with regard to the fact that, that case basically opens the door to any person filing a civil suit against the president and potentially harassing him. And the court wasn't convinced in that case that that's enough reason to preclude the subpoena for the president's deposition there and potentially going to a civil trial. And in fact, after that case was decided, there really hasn't been an onslaught of cases of people filing suit against the president. And the final issue is basically that in Clinton v. Jones, the federal court ended up deciding whether or not a subpoena could properly go against the president. And the same thing is true here. So even though it's true that state district attorneys might be, incentivized to file subpoenas against the president or that target, people related to the president, at the end of the day, a president can always file suit in federal court and have a federal judge decide whether or not that subpoena is proper. And so that backstop exists throughout. This was also a really important case, and I think it also brings up the issue of whether or not an investigative body can do its job and get the information it needs to look into potential criminal wrongdoing. And it brings up the question, just like in the Mazars case, about whether or not the court will hold this president to be basically a king who has, who can stop any lawful subpoena just because he doesn't like the subpoena, or whether the court will enforce the rule of law. And we'll have to see how they turn out. And we should be getting a decision in these cases by the end of June. For full details on the background of these cases, as well as an opportunity to read the briefs that CAC filed in these cases, you can visit our website at www.theusconstitution.org, or you can click the link in the body of this post. Please share this video with your networks, and stay tuned to our social pages for more alerts on news and case decisions that impact the US Constitution, our nation's founding charter. Thanks so much for joining us today, and have a great day.